Good morning. My name is Kristin Garcia, and I'm here on behalf of Michelle Staples from our office. I'm an attorney with Jackson Titus. We're located in Southern California, and I practice environmental law in a variety of areas, including groundwater, of course, but also air quality, climate change, energy. Since the enactment of the Sustainable Groundwater Management Act in 2014, my practice in groundwater has grown substantially. And so today, I'm going to talk briefly about the requirements under SGMA, but also some of the strategies we've developed in advising our clients, particularly on the private sector side, for participation in the Groundwater Sustainability Agency governance structure and developing the groundwater sustainability plans that will govern the basins where they're operating. So here's my general roadmap for today's presentation. As I said, I'll briefly discuss SGMA and its general requirements, as well as focus on groundwater sustainability agencies, their powers, their formations, which is happening right now throughout the state, and opportunities for private participation in this governance structure. So the general SGMA framework is that it it's a mandate for the state's high and medium priority basins. Step back and give you an idea of how many basins we're talking about. The state has identified, I believe, 515 basins. That includes basins that are divided into sub-basins. So we're talking 515 distinct groundwater management systems in the state. Of these, 127 are high and medium priority basins that are expressly required to comply with SGMA. There's also a provision in SGMA that authorizes and encourages the remaining basins that are low and very low priority designations by the state to participate. However, there have been amendments since the original enactment that make it clear that certain provisions don't apply. And I'll touch on that a little bit, but if you have more questions, please feel free to find me afterward and we can discuss. So we talked about the basins that this applies to. There are certain local agencies that are eligible to elect to become GSAs. These are the Groundwater Sustainability Agencies. I'll refer to them as GSAs throughout the presentation. It could be local counties. In fact, if no other agency elects to be a GSA and it's one of these basins that's subject to SGMA, the local county will be the default agency. Otherwise, water-related agencies, water districts, irrigation districts, and the like can elect to be a GSA for a basin. There are, obviously, some of these special districts have jurisdictional boundaries that maybe don't overlie the entire basin. In that situation, there are a couple situations that could arise, which I'll talk about a little bit under GSA formation, but that some of our clients are dealing with, and it presents opportunities for possibly new legal agreements that would allow private well owners and other private parties to participate, perhaps better than they would be able to under SGMA's other provisions. My next slide will enumerate just some of the powers that are provided for in SGMA for GSAs, and these are found in chapters 5 and 9 of SGMA, and one of perhaps the biggest power that they're given is to develop what's called a groundwater sustainability plan for the basins it overlies. A GSA can overlie multiple basins and manage multiple basins, and it has to develop a GSP for each basin. At least that's recommended by the Department of Water Resources. So there are different deadlines by which a GSA must submit its GSP, and this depends on whether or not it's managing a basin that is deemed in critical conditions of overdraft, or it's a non-CCOD basin. I believe there are just over 20 basins throughout the state that are in critical conditions of overdraft, and the majority of those basins are in the Central Valley. There are another 5 or 6, I believe, in the South Coast area of the state. So, as originally enacted, SGMA required GSAs to consider the interests of all beneficial users and users of groundwater. But this was along with one other provision that authorized GSAs to appoint an advisory committee. This was sort of the extent. of how private parties could participate and be represented. There have been subsequent amendments, which I'll run through, which provide further opportunities, including agreements with the GSAs for implementation of the groundwater sustainability plans and funding mechanisms, as well as express authorization for mutual water companies and water corporations to participate on the boards of these governance structures. So once the GSP is developed, it's then submitted. I should step back and also say that June 1st, so less than a month ago, the GSP regulations went into effect, and they set forth the basic criteria that needs to be included and considered in developing the GSPs for each of these basins. And so the Department of Water Resources has the jurisdiction to review and approve, conditionally approve, or ultimately reject these proposals for groundwater management. And the GSAs have a requirement to report every 5 years, basically milestones, on where their progress is on achieving sustainability in the basin. And this is, the GSPs have a planning horizon of 20 years. So within 20 years, according to the conditions within the basin, there are certain metrics that will be applied to the conditions in the basin, and that will lay out how each individual basin is going to achieve sustainability. It's kind of abstract in concept, and I apologize for not being able to provide more concrete examples, but as you can imagine, the conditions in every basin varies. And so this is why private participation, local control matters so much under SGMA, so that those conditions are accounted for properly. So this is a slide that I referenced earlier regarding the various powers that the GSAs have. They can impose fees, they can set well extraction limits, they have an enforcement power where they can investigate properties and facilities for compliance, and where they find violations, they can issue fines. They can require that wells are metered and report their extractions. They can also transfer, deliver, or exchange water or water rights as necessary and proper to carry out their mission under SGMA. Oh, I'd also like to point out that where there is some land use overlap, as you can imagine, and here their authority obviously doesn't supersede local land use authority, but it will work in collaboration, specifically, for example, where there's a proposed development and water supply assessments are prepared, and some of that development, or, well, not all usually, but some of the water will come out of groundwater. A hard look will be taken, particularly if it seems like it could compromise the quality or quantity of groundwater that will be used or is in that basin. So those vast powers make it important for participation in the GSA. So the GSA deadline, formation deadline, is next June 30th, 2017. As I said earlier, formation is ongoing right now. And eligible entities are counties, like I said, but also local agencies that have water supply, water management, or land use responsibilities overlying a groundwater basin. The procedural requirements are listed here. I'm not sure whether or not you care about these, but I put them here for materials to reference after my presentation today. The one bullet point that I really do want to talk about is this last one, which talks about GSA overlap. So what happened when SGMA was first enacted? GSAs, well, certain agencies, not GSAs yet, but certain agencies said, okay, how do we implement this? We're the first ones, we're the pioneers who are filing our first GSA election notices with DWR. And there ended up being some overlap. In fact, in many basins, and I can't give you a statistic, there is overlap. We have clients where we're resolving overlap. So there is a provision, in fact, there's an entire chapter in SGMA that talks about the State Water Resources Control Board having intervention authority. The State Water Resources Control Board can intervene under a number of scenarios that are enumerated in statute. One of them is if it's a high or medium priority basin subject to SGMA, and after this June 30th deadline, it determines there is no basin, then it can intervene. It can deem it a probationary basin, and it can intervene, which essentially means it can manage the basin in lieu of the local agencies. This is significant, as you can imagine, because it's basically management from Sacramento and not local. So this is, the overlap has to be resolved by June 30th in order to avoid this outcome for high and medium priority basins. The resolution process for overlap, like I said before, I hinted at, provides an opportunity for JPAs or memorandum of agreements where various parties can come together, usually the GSAs that have the overlap, but also outside parties, to help negotiate how governance should be resolved here. Once that is done, it's submitted to the Department of Water Resources, and there's no longer an overlap in the eyes of the state, so there's no longer the risk of intervention by the State Water Resources Control Board. But what's better about this is that it does really provide more opportunity for the private sector to participate instead of perhaps just local public agencies. So this segues well into my next slide, which is how to participate as a private party. So we talk a lot about these 4 options. The advisory committee option was the first option that I mentioned at the outset of my presentation, which talks about, or there are 2 provisions in what I always refer to as original sigma, which says that these beneficial uses and users, here on the right hand of the screen as you're looking at it, must be considered throughout the GSA formation process and the GSP development and implementation process. I've looked a number of times at the GSA filings with the state, and what I've found is, in the beginning, advisory committees tended to be something that was included and considered expressly in the public hearings. But I looked this morning at the last 10 or so elections, and that doesn't seem to be what these agencies are interested in. It seems that they feel maybe their hands are a little tied if they commit to having an advisory committee of all of these different interests. So instead, they commit to working with these interests. They commit to providing outreach to these different interests. And so the advisory committee, I think what we're seeing generally is this isn't the best way for these users to be represented. And clearly the GSAs sort of feel the same way because they're not really including them. In 2015, there was an amendment, 2 amendments, this is the first I'll discuss, to SIGMA, which authorized GSAs to enter into written agreements with a private party to assist with the implementation of a GSP, and it also authorized funding for this private party. Because not all GSAs are formed yet, and very few are even starting to think about GSP development, I have not had clients where we're specifically working on these sorts of agreements, but they are on the table and they are things that we're thinking about. There's also an amendment under SB 13 that allows, I said this earlier, mutual water companies or water corporations to participate as a GSA because they understand their role in providing water locally. And so this, again, is the private sector being allowed to participate expressly under SIGMA, and they can serve on a GSA governing board or board of directors, whatever it's called by the local GSA. And then the last one that I want to talk about is special legislation. So I'll use the rest of my time talking about this. Where there is local consensus for perhaps a different structure than the ones we've talked about, which can be challenging unless you're a water corporation or a mutual water company, then another option is special legislation. So SIGMA provides, in one provision, it enumerates water agencies with exclusive groundwater management authority. And so if you can opt out of managing groundwater under SIGMA, but you're still listed there in statute. So one of the things that we've seen, and this is the bill right here in front of us, is SB 37. It was introduced this year. And I'm going to jump to my next slide really quickly because this shows the area of the state that we're talking about. So if you'll permit me, This is the Kings subbasin. And you can see that there are lots of different areas that want to be managed under different legal agreements. What this bill addresses is this area here and a little bit more into here. So what this legislation proposes is, in the provision I just mentioned, adding a brand new GSA or groundwater management agency specifically for this area. What we've typically seen with GSAs is the normal filing procedure. A local entity like a water district's governing board holds an election, and they file their notice with the Department of Water Resources, and they wait for the time to run, and then they become a GSA. Here, a local legislator decided, I want to enumerate this in statute. We have support for this at the local level by a variety of stakeholders, and so he introduced this legislation. It includes 7 board members, and this is how it's comprised. There's an irrigation district, the Fresno and Tulare County Board of Supervisors. There are several cities that would overlie this basin, and one of the city council members from all of those, not one from each, would be elected. And then there are special districts here. These are irrigation districts, water districts that are not governed by the county's Board of Supervisors. And then there's also another seat for special districts where you have drinking water suppliers. Finally, these 6 that I just listed will come together and vote on an agricultural representative. Only 4 of 6 votes are needed to approve this member, but there is a specific spot for agricultural interests. So that's my last slide, and I know I'm over time, but I quickly just wanted to say we're starting to see now that we're about a year and a half, almost 2 years, I guess, into Sigma implementation, how private parties can leverage these different statutes and other means, other legal means through JPAs, memorandums of understanding or agreement, to have a little bit more power in this process, because they are ultimately very impacted by what's to come under Sigma for the next 20 or 25 years. That's it. Sorry about that.
Thanks. You mentioned SB 13 and how it allows mutual water companies and water corporations to participate in GSAs. My understanding is it doesn't require that participation it doesn't require a GSA to allow that participation. What are you seeing in the field in terms of, are there any cases where there are conflicts of interest, and how are those being resolved or not being resolved for the participation of the private entities?
The situation that I've experienced, we do have one mutual water company client that we're working with on this very issue, and the GSA formation process hasn't begun yet. We're waiting for basin boundary modifications, which is something I did not talk about during this presentation, but we're waiting to see how basin boundary modifications are resolved, and then we will determine how to go forward next. But we are in communications with the possible agencies that overlie that basin to determine whether or not and to what extent our client will be involved. Sitting on the board would be our preference. Whether or not that is ultimately negotiated remains to be seen, but it is, at least or for one of my clients, that's something that we will push for very hard.